to accept that if I don't believe
Sir,
that it's
it will be placed on your table, but I will be referring to that today, so
Is
it's
it
been
law?
given to you.
Is it verified law, Your Honor?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was provided.
I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may. As I have not consented to or agreed to accept any paperwork that.
Sir, it's been
Is not-
provided to you. It's
So are you
something I'm going to
making-
consider. You don't want to
Are you
read
making-
it.
are
You want
you
to
making a
disregard it. That's
judicial-
your choice.
Are you making a judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not. So my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir. But based upon you providing that information, again, I did I was provided with the COVID-19 illness reporting protocol. I wanted to make sure that I had the most recent information that at least the county of Waukesha is operating under. I also verified with court staff that the location at which you are seated is not within 6 feet of any other individual in this courtroom. Is there any other information you think I should know as I consider your request for an adjournment today?
Yes, I find it hard to believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically-
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate communication form.
It could be verified because I was told when I was brought down here that everybody knew that I was on a COVID protocol. That's why everybody
Because you advised us.
That's why, no, because the jail advised them. That's why they had to wear masks to bring me down. That's why I'm essentially on a protocol that doesn't allow me out of my cell until my results come back. So I'm not allowed out of my cell at the moment because of the protocol that the nurse himself placed me on, that the jail confirmed. That is very easy information to obtain.
Sir, I have an attorney for the county here who will verify that none of that information has been provided to me due to HIPAA
I don't want you to think I'm
requirements.
arguing.
So I'm not arguing it with you,
I
sir,
know, I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go.
consent or agree to being cut off right when I'm trying
All
to
right, I'm just
provide
going to
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me if you so choose.
That is incorrect because just yesterday, you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue, and I have to wait for the results of my test. And until then, I am on a protocol which restricts me to my cell. That is very easy information to obtain. And I find it very hard that Your Honor cannot obtain that information, but can obtain a way to communicate with jail staff when there's a witness list involved. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. Like I said, I've never had this happen.
Let me clarify that. That was a pretty ambiguous question. So, you reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, that it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
But the jail can, because they control the movement. They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the moment.
It's not, but I'm saying, how can I tell you, how can I answer what you're asking me? It doesn't make sense. We all understand that the jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not here to talk about inmate movement at the moment. What I'm asking you is, do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Do you know what type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be at least on this protocol until the results come back, which he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be obtained, are you willing to submit to a rapid test? I'm
not willing to submit to anything right now until we take care of the issues that's at hand. I mean, I've already been placed on the protocol. I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results, at bare minimum. I don't think I'm asking something that's
Sir,
impossible for
if
Your
I
Honor to
can
grant.
make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results of the test I already took?
But you're telling me you're scared, you're
Yes,
fearful?
I am.
But you don't
very.
want to take a test that might tell you today?
I took the test that he gave me.
And
if
you're
he
telling me
felt-
that test result won't be available to you until at least Friday?
At least Friday, that's what I was
So
told.
tomorrow.
I was told that I would be placed
day
on this
after.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor.
Okay.
I have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID. There are tests that can be what we call rapid tests, or what are called rapid tests, that are available. And then there's these other tests which take a few days. Again, I'm not a scientist, but I think the general belief would be sometimes the rapid tests are accurate, sometimes they're not. Sometimes people test negative when they're really positive. It just kind of depends on the circumstances. But it's my understanding a positive test would be pretty accurate. And then there's other tests that take a few days for the results to come back. It really depends on the lab that's being utilized, et cetera. I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I was work
told,
with-
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this? What is this about?
I'd like to welcome my guest for this hour, criminal defense attorney Marie Pereira. Marie, let me start with this for you, for the viewers. We are pausing it there. So much information to absorb. We know the defendant has finally, we've gotten through the judge's questions, I think, to understand what he's requesting. He wants an adjournment because he is falling under the jail's COVID-19 protocol, and the judge has had to ask a lot of questions to get some information directly from the defendant, because she's right, with HIPAA, she certainly can't access his medical information, but clearly he was having symptoms. They have done a test, they being the jail, not a rapid test, results not back until Friday. He's asking for an adjournment, and then he added to that, I'm scared, Judge, I'm scared. I've been vaccinated. I can't even understand why it might be COVID. So let me first just get your general response and how you're feeling watching this so far.
This makes me very anxious. He's very argumentative with the court. But to play devil's advocate, if he's having COVID-like symptoms and he lost his sense of taste, they did an exam for him. It should have been at least a rapid test followed by a PCR to make sure that the rapid test results, whatever that was, is accurate. Just the fact that he's in court and he may have COVID or may not have COVID doesn't make any sense to me. And I feel like there should be a better coordination between corrections and the court, even with HIPAA considerations. If he has COVID, he's entitled to some type of an adjournment.
And Marie,
If
that's
he thinks
what
he has it.
Right, and Marie, I have to jump in, and I'm sorry, but you said something I want to agree with and just comment on, and that is the communication between the Department of Corrections and the court, the judicial, because when I was on the bench, I had to have those communications all the time, because they'd say either, oh, we're not going to bring this defendant over, we're not going to bring this prisoner over, or we did because we thought it was today. It was constant communication about these very things, and so I too am a little bit surprised that the judge says the only information I have from you, Defendant Darrell Brooks, is from you, not from anyone else, including the jail that brought over a prisoner that may or may not have COVID. You've raised some great points, but I have to hit a pause on our conversation as well, because we need to take a short break. When we come back, we're going to get you back into court as Darrell Brooks continues really to interrupt the judge. We'll be back.
Families of Sandy Hook school shooting victims seeking damages against InfoWars founder Alex Jones.
The Alex Jones defamation trial. Live coverage on Court TV and streaming gavel-to-gavel on Court TV apps and CourtTV.com.
Tonight on Closing Arguments, we dive deeper into the investigation of Debbie Collier. Our experts break down all the latest as the search for her killer continues.
Closing Arguments with Vinnie Politan. Tonight at 8, 7 Central. Only on Treatment.
Breaking news. What was scheduled to begin at 2:30 as really a housekeeping hearing to ensure all the logistics are worked out before the actual trial starts tomorrow in Wisconsin against Darrell Brooks. Well, instead of that, Darrell Brooks has made a motion to adjourn the hearing, the trial, because he states that he falls under the COVID-19 protocol. And I would assume that's the one of the jail stating now to the judge that he was tested for COVID. A lot of interrupting. We hit the pause button because this argument between the court and the defendant continues. Let's get you right back where we left off.
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need, what's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very fatigued. And I said, man, I don't know if it's just me being tired, or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no, anybody knows their body. I said, this got to be something more, because I'm really, I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said, okay, now I need to put the medical sick
When did
card
you report these symptoms to the medical people or to even just a correctional officer?
A few days ago. Over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired. Usually I don't just jump the gun and say something's wrong, because it may just be, it could be anything. So
when did you report the loss of taste?
I reported the loss of taste last night.
And was it after that they told you they wanted to test you?
No, they didn't tell me till this morning that they wanted to test me.
What other symptoms are you reporting at this time?
That was it so far, just the fatigue and the loss of taste, which is the reason why I was told that I had to take the test. Which I was told at that time also that the earliest my results would be back would be Friday.
And you said at this point you're not willing to take a rapid test.
Well, they said this is the test that they do. The nurse was very clear in what he was telling me when he told me how to test, because like I said, there was a lieutenant and 2 officers right there while the whole thing was going on.
I understand all of that. I have a very specific question to you, sir.
I was asking them questions, and he specifically told me that this jail, this is the test that they do. They do not do rapid tests. I didn't even ask about the test because I know nothing about the test. This is what I was told. And after he told me that, I said, okay, fine, just do the test and I'll just sit on the protocol, because at first when he told me, you know, you're gonna have to be on a protocol where you're isolated. I said, okay, fine, just do the test. I'd rather you do the test and make sure that I'm healthy than to just refuse the test and just say, I'll just wait to see if I get better or something like that. So I said, yeah, just go ahead. And that's what I was informed. Friday would be the earliest that I would get the results back, and I would be placed on a protocol which is called isolation, where I'm not allowed out of my cell.
Anything else, sir, you think I need to know about this issue as I consider your request?
No, at this time, I'm just telling you what I know. Multiple officers were there. They can tell you the same thing that I'm telling you now. like I said, a Lieutenant Chamberlain was there, 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is.
So no information's been provided to you that there's like either a lockdown or some type of a restriction due to any like concern over COVID at this time?
I would never have that information because, like I said, I'm limited in the pod that I'm in. I have no interaction with any other inmates, and my interaction with staff is pretty limited.
All right, thank you. I appreciate that additional information. I know, sir, what I've provided to you is generally the, for employees, I fully recognize that the jail may have different protocols just because of it being in a correctional facility, and inmates are, of course, or can be very close to one another. And so I don't want to presume that this is exactly what they follow. And so I'd like for them to tell me what their protocols are as I consider this request. At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom. As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting. You're under.
Good for the judge. This is exactly what I would have done, which is ask his permission to go talk to the jail to find out what the protocol is. 2 things. I'd love for you to tweet us at Court TV. One is, if the jail doesn't do a rapid test, why do you suppose it might be that the court would be asking for a rapid test? Would that be sufficient? The second thing is, did you notice Darrell Brooks just said, I'm in the mental health pod? And yet, remember, the judge had to make a finding that he was competent in order to represent himself. Do you think those 2 things can go together? We'd love to hear from you. Squeezing in a quick break. We'll be right back with more of this hearing.
They're from Credit Karma Money.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you. Back to the case of the deadly Wisconsin Christmas parade. We are watching a tense motions hearing with the defendant, Darrell Brooks, sparring with the judge. He's asking for the trial to be delayed pending the results of a COVID-19 test. You haven't missed any of what's happened. Let's get you back into that courtroom.
Despite you reporting fatigue, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table.
I got a knee on the chair.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof, that he is.
How could
Mr.
that?
Brooks,
How could that even?
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object. Your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd encourage you to use paper and a pen to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand that this is a place of dignity, it is a place of respect, It demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. And also, I believe she would be able to provide information if the court ordered her to do so. I believe that even if he is on COVID protocol, it will have zero impact on his ability to prepare for this case. As we've learned already, and I'm prepared to make a further record, he has all of his discovery materials within the confines of his jail cell. He has a tablet made available to him in the confines of his own jail cell, and he has the ability to use a conference room in his pod. I don't believe the COVID protocol would interfere with his ability to access that conference room whatsoever. But again, I could verify that with the jail administrator if the court thinks that's an appropriate fact. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
I never once said...
Mr. Brooks,
I never
have
said,
an opportunity momentarily.
No,
you
I
need to stay
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks, it's not your time to speak.
No, I respectfully object. I never reported saying what day. I never said a day. And if she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little bit of leeway because we are outside the presence of the jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect tested for COVID-19. How could that be a delay tactic? If that was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
All right, Mr. Brooks,
verification?
Mr. Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted Attorney Opper twice.
Be able to speak up.
You're now interrupting me yet again. We all were polite and had you provide information.
Not polite. That was abuse.
That's at least the third interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr. Brooks, let me finish.
No, because that's...
So he's outright refusing to listen.
I would not sit here...
Talking over me at the moment.
Anything. I didn't refuse anything.
Mr. Brooks, we are at the point yet again where I will put you in the other courtroom because you are not able.
I don't consent to being removed. I have not waived the right to be present, and I don't agree with that.
Mr. Brooks,
does the record reflect?
I have provided you on multiple occasions and it's should be in front of you.
No,
and it's not.
I don't acknowledge that. I haven't agreed to it.
You have been advised on multiple occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because You are a litigant. You're both a named defendant. You are now acting as your own attorney by representing yourself.
I don't recognize the name
that all of the rules of courtesy and decorum apply to you.
I don't recognize that name, Your Honor. That is not who I am.
Supreme Court Rule 62.02 details many of the requirements for courtesy and decorum. I've referenced a couple of them on multiple occasions, including that sub 1 sub F of 62.02, that proper conduct and attire is expected within the courthouse, and where possible, individuals, including yourself, right, are to refrain from creating disorder and disruption. Sub H, you're supposed to conduct yourself in a manner which demonstrates sensitivity to the necessity of preserving decorum and integrity of the judicial process. You have been advised multiple times, sir, of the expectation that this court has that you conduct yourself in a civil manner. You've been advised multiple times that this court will not tolerate disruptions, interruptions, that when you do that, you run the risk of forfeiting your right to be present in the courtroom. As you know, I have available the courtroom next door that's connected to the holding area. It is connected by audio and visual means. It provides you an opportunity to meaningfully participate by also giving the court the opportunity to control the decorum, to control the disruptive behavior, because primarily your disruptive behavior is repeated interruptions of this court, talking over this court, now talking over the prosecutor. I appreciate that you have not interrupted me for quite some time. So at this point, though, I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audio-visual means. At this time, I would like to hear from the court administrator, especially as it relates to the protocol.
Jail administrator.
Did I say the court administrator?
Yes, that's all right.
That's okay. We're in court, and I would like to hear from the jail administrator. Thank you very much. And just to get some general information and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who are present. So I believe we have Angela Wallenhaupt here, if she would come up to the witness stand.
Your Honor, still with us, Marie Pereira. Oh, Marie, so much to talk to you about. First of all, let's talk about the reality of pro se defendants. They are not attorneys. They're never going to use all of the same verbiage or understand all of the legal proceedings because they're not trained lawyers to try a case. On the other hand, many people understand you can't interrupt. You have to follow the judge's rulings. There are rules in the courtroom. What do you think of the fact that he continues to not be able to adhere to even the simplest instruction of do not interrupt me again? You can object in a minute, don't interrupt me again, and yet he keeps doing it.
I think it's intentional. I think it's willful. And while I don't think he's been diagnosed with a mental illness, he definitely shows signs of a personality disorder. He is narcissistic, antisocial, and he's purposely disobeying her commands to stop interrupting her. And he's doing it for a purpose of delaying the procedure. And he's just basically so full of himself that he cannot follow norms, and this courtroom has rules. It's a problem for him.
So what do you think that options are, Marie? Viewers have asked, what do you do? What do you do as a judge with a pro se defendant when you get what you get? I was on the bench, and it is what it is. But the reality is the last 2 days, and she just read him the warning again that says if you can't comply with courtroom decorum and follow the rules, then I'm going to have to send you to another room. And actually, I think that's a pretty creative way to deal with a defendant who refuses to listen to the court's instructions. But what do you think of that? Do you think that's an appealable issue, or do you think that's a good compromise?
I think it's a good compromise, and it's basically a timeout room because he's acting like a spoiled child. And that's all she has to stop him from interrupting the proceedings. He's being outright rude to the court, and I think this is going to continue. I don't see how they're going to continue with this case with him behaving the way that he is right now.
And that was my next question for you. Do you think we're going to get through the case? And it's a really hard position to be in as a judge. They have a constitutional right to represent themselves, but that's not unlimited. She's made a finding he's competent. I wonder, as these proceedings continue, do you think there's any opportunity for a new competency evaluation to be ordered by the court, or do you think she's going to get through this and he's going to represent himself until this is finally concluded?
I think she's trying her best to afford him his right to represent himself, but I do think that she needs to use her judicial discretion at this point to consider another evaluation, because his behavior is just spiraling out of control, and the case has not even really opened up for the jurors to hear his side of the story yet. I think that when she made the decision not to afford him a standby counsel, that was an error on her part, and she could have used her judicial discretion to do that. Perhaps if there was a standby counsel, he could step in when they have to put him in that timeout room.
That's a really good point. Standby counsel, of course, for those viewers just joining us, meaning that there's an attorney on standby in the courtroom watching the proceedings, familiar with the case in the event they need to do anything. I think that is a really great idea as well. All right, we do need to take a break. This is not a hearing to miss because the fireworks continue. Stay with us. We'll get you back into that courtroom on the other side.
It was a holiday parade that quickly turned tragic.
Evil has arrived and it's shown what it can do.
Darrell Brooks is accused of killing 6 people when he drove his vehicle through a crowd of spectators.
In a surprising move, Brooks waived his right to an attorney and instead will be representing himself.
Our cameras will be inside the courtroom as a community searches for justice.
The deadly parade crash trial. Live coverage today, only on Court TV.
Wisconsin versus Darrell Brooks. Let's get you back inside that courtroom. Here are the 2 issues that we have to wait to find out. Number 1, will this trial be delayed because of a pending COVID test of Darrell Brooks, the defendant in this case? And number 2, will he end up being kicked out of the courtroom again today? Let's get you back to court.
To put on a proper defense, which is my constitutional right to be able to do so. I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented.
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
a
Wollenhop.
estoppel either.
Although Mr. Brooks is under a COVID protocol, is he still allowed to review his discovery materials in his jail cell?
Yes.
Jay, for relevancy.
To your knowledge, are those materials?
The objection overruled.
I'm sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that,
he
yeah.
still
I object
able-
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be
objection
able to-
is overruled.
Will she be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I
you
am
haven't.
turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object just like she objected when I was asking
Right,
questions.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal, and then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms. Molenhop, while on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've indicated
I
previously.
object to that respectfully, Your Honor.
So an objection goes to whether there's lots of rules of evidence that apply. But if you're objecting to her answer, that's a different thing. You can argue the meaning of that later.
Question,
Okay,
not
the
the
objection.
answer.
But then you have to say objection before she answers. You objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail, correct?
I respectfully object to that.
Overruled, she may answer.
Correct. He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am. And
So you're going to overrule everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
it
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic code. It
I
has
don't
the
see
rules
it.
of evidence. Well, it's on your table. It's behind the microphone, and it's there. I've provided it to you as a courtesy so that you have that available
You did not
to
provide
you.
anything to me.
All right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
they
to the
have-
other courtroom.
something
I've
that-
provided ample opportunity
I've
for
never-
Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack
don't
of
give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't give
I'll make a
consent.
more full record when we
I
are
don't
open
give consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
from
Reporter,
being
the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.